Welcome to today's webinar on the Civil Resolution Tribunal. We're going to get started in just a moment, just letting the last few people get signed up. And we'll just get Grant set up with his sharing screen. Welcome, Grant.
Hi.
Hi.
It says I cannot start my video because you have stopped it.
Oh, there we go. There you go. So you're in now.
All right, perfect.
Great, welcome. So welcome, and it looks like pretty much everyone has signed in. Thank you everyone for joining us today on this for this webinar on the Civil Resolution Tribunal. The tribunal itself, the Civil Resolution Tribunal, started operations in 2016, and it was specifically started to focus on strata corporation matters. Since then, it's broadened its scope and its jurisdiction. And while it doesn't particularly directly apply to residential tenancies, because many rental units are in strata corporations and in strata units, condos and such, oftentimes situations do arise where landlords will find themselves at a proceedings through the CRT, whether it's with their tenant as part of it, as a party to this, or directly just with their strata corporation or a supplier. So today we have Grant Haddock to present on this. Before I turn it over entirely to Grant, just a few housekeeping things. If you want to ask a question throughout today's webinar, please feel free to do so using the Q&A box. So you'll see at the bottom of your toolbar there, you should have an option for a Q&A box. Like I said, ask questions throughout the webinar. We will get to the end, but like I said, ask them whenever you think of them so you don't forget at the end. And Grant will stick around to do a Q&A at the end as well. And also to stick around to the end of today's webinar to get more information about an exclusive education opportunity happening on April 8th, which will feature some Scott McGregor from the Residential Tenancy Branch Compliance and Enforcement Unit, as well as the Honorable David Eby, the Attorney General and Minister responsible for housing. So again, stay tuned for more details on that at the end. So without anything further, I'd like to hand it over to Grant Haddock from Haddock & Company, today's presenter and sponsor for today's webinar. Thank you.
Oh, thanks. Is my screen share on? Are you guys seeing my slides?
We can see your screen. It looks though it's not in like slideshow view.
Yeah, so I've learned that whatever I'm using here, which is a Microsoft product Surface, it does. If I go to slide view, I will not be able to share my slides with you. It'll stick on that. So you're gonna get the whole thing. So if you're really curious, you can look to the left side and see what's happening. So we'll do it this way. Well, good afternoon, everyone. My name's Grant Haddock. I'm the principal of Haddock & Company Lawyers, offices in North Vancouver and Victoria. I'm going to do the CRT presentation today. I've been doing, and my group here, my team here has been doing landlord tenant law for about 30 years now. Do a lot of strata property law too, and a lot of work with nonprofit housing and housing cooperatives. So I'm intimately familiar with the CRT, short for the Civil Resolution Tribunal. So I want to get something like out there in the open right now. I do not hate the CRT. Presentations before to various groups, mostly to strata people, and some to the co-ops and societies, and a lot to the nonprofit, who are like you are mostly landlords. And then I would have done the presentation, and then everyone, I look at the crowd, which might be large, and they're sort of looking there like furrowed eyebrows and saying, "Oh gosh, Mr. Haddock, you really hate the CRT, don't you?" And I go, "Well, no, I don't. I just have a really bad attitude about the CRT." Like being a lawyer, most lawyers have like either suspicious or have a bad attitude or bad experiences from the CRT. And I'll explain that further. But at the end of the day, you'll probably will say, well, Mr. Haddock seems a bit, unhappy with the CRT. But I'm going to say that overall, the CRT is probably good. because the CRT provides access to justice where sometimes justice is denied because of cost. And that means guys like me getting involved because we're expensive. And as I'll show you shortly, the CRT doesn't allow lawyers to participate at their tribunal. So you could not hire me to go in there for you as your lawyer, fronting the whole thing without you participating at all. CRT is designed to make people participate and without lawyers, but that of course is not true. Lawyers always operate in the background on these things. So no matter how negative I might seem about this whole CRT thing, the bottom line is I think the access to justice angle on the CRT and what they've done overrides all my concerns over evidence. It's rough justice and it's imperfect justice, but at least it's justice, where sometimes justice just doesn't happen because of cost and complexity. Let me just see if I can move these things down now. Oops, where are we? So here's what we're going to try to do today as far as objectives. I'm going to also get into areas where you as landlords might run into the CRT. I guess if any of you are landlords with properties renting in strata corporations, this will be especially interesting to you because we're running into, at my firm, a lot of situations with landlords in strata corporations, running into jurisdictional issues between the residential tenancy branch and the Civil Resolution Tribunal. And it's getting more complex by the day because the CRT believes it has jurisdiction over everything. And their legislation actually says a bit of that. Now, they don't, certainly the CRT has been wandering deeply into the Human Rights Tribunal and deeply into the Privacy Act and their tribunal. They haven't really gone that much into RTB, residential tenancy branch territory, but we're starting to see that. I've had a couple of cases where they've said, well, maybe it goes to RTB, we'll take jurisdiction over it anyway. And so that's one of the things I'd like to prepare you all for, is either mistakenly or by design, the CRT takes jurisdiction over something that may seem more likely or better suited for the RTB. So we're going to teach you to be aware of a Civil Resolution Tribunal, its existence, how to react to claims made against you or claims you might make under the CRT, understand the usual steps in taking a dispute to the CRT, consider the impact this could have on your operations, because there's always, you got to think about how you're going to run your business when you got the CRT out there, and explore ways you can prepare for disputes submitted to the CRT. Here's the outline we'll try to get through today. I think we'll have no time, or we'll be able to get through it easily. We'll introduce you to the CRT. We'll look at the context, disputes in residential tenancy industry. That's what you're all worried about. Impacts on your operations and how best to get you prepared for this. So here's the questions we're going to look at. What is the CRT? How does it work? And what are some of the practical concerns with the CRT? So it's a brand new tribunal, as Hunter said. It's the newest of the tribunals. It's a completely online tribunal. As I'll explain later on, I'm not aware of a single in-person hearing that's ever happened. It's all been by writing, submitted through the internet. No witnesses testifying, no affidavits, just basically the Wild West of evidence as far as lawyers are concerned. CRT has been deciding strata property disputes such as fees and fines, unfair actions by strata councils or majority owners. They interpret and enforce strata bylaws, the Strata Property Act and the regulations of that act. They deal with problems with meetings and voting and proxies. And the big issue right now there is all of the COVID-related AGM and the platforms like this platform, for instance, Zoom, the ability to correctly run an AGM or SGM through Zoom, where they've never done it before, and all the procedural issues that can come up. So I've got, in this office anyway, a big crop of CRT claims from owners or strata corporations attacking the validity of these electronic meetings. Not the fact they can actually have them, because specific legislation has been enacted to allow stratas to specifically have electronic meetings, but the process during the meeting. And then a big one, issues with repairs in common property. And they started doing this back in 2016, and it was exclusively just strata. to start off with. So they're really testing this out. And one thing you should know about the CRT is that the common law world, and I mean everyone else uses common law, like English type law, like England, Australia, Ireland, South Africa, even all those common law jurisdictions, and the Americans too, to a certain extent, are watching this to see what's going to happen, because this is the future of litigation in our lifetime. This is what it's going to look like. No more, and the pandemic is only going to accelerate that, because I've not seen the inside of a courtroom since March. I've been doing all my court hearings like this, with my headset on, a tie on, because and the judge on the screen and the opposing counsel, or just by telephone. And that's how it's and it's great. Super reduces costs for my clients. Productivity is through the roof for us, and that's the future. And the CRT is part of that because it's completely online. It's cheaper, it's faster, access to justice again. And other jurisdictions are looking at it very closely, and they're looking to implement exactly what's happening here. So when I talk about all the failings that the CRT might have with regard to process and evidence, there's this juggernaut of government impetus and among the CRT itself to make this work, regardless of how imperfect it might be, because there's a lot at stake, because whoever is in charge of all this can import this as consultants or whatever and monetize it to other jurisdictions, and they'll be looking to do the exact same thing. So currently, CRT, as of today, they're doing small claims of $5,000 or less, and that would be of most interest to the landlords, because you might get a few of these happening, because any sort of debt claims. Sometimes when clients have come to me and say, well, someone owes me $2,000, or my garbage contract happened, or a contractor, ripped me off for $5,000. I'll say, well, you don't want to hire a guy like me because you'll pay me $7,000 to get you $5,000. It doesn't make any sense. Now it suddenly does make sense, because you can do it yourself. It's really easy on the website, and you get a fast decision. CRT advertises in decisions in 90 days or less. Sometimes that happens. Most of the time it doesn't. The CRT is also doing minor to moderate motor vehicle injuries. So back before we heard that ICBC was going to no fault, and that's going to happen this May, ICBC sought to reduce their costs, and the CRT was happy to oblige by taking over the minor to moderate motor vehicle accidents. And this is up to, by that it's like $50,000, is around in that range. And this is an interesting one. They took on roommates and shared accommodations, which is really interesting, because that was a question I struggled with when people called me and they'd say, well, I got a problem with a roommate. Where do I go? And I'm going, well, where do you go? The Supreme Court. Incredibly expensive, very complicated, all for a roommate issue. Well, thank goodness the CRT and those who handle them saw this as something that the CRT could do, and they can. Again, this is one where you're, as a landlord, you're going to have to watch out, because you might get pulled into this thing, or the CRT might decide that you're not really a landlord situation under the RTB, that you're really a roommate or shared accommodations, shared facilities, and that they'll take jurisdiction over it. And then the last and the newest of the bunch was all society matters and all cooperative matters. And so for me, I worked for a lot of housing societies and a lot of housing co-ops. So that's where I'm seeing a big uptick on activity at the CRT as well. And my view on it is that they're not done. I was afraid at one point that the CRT would take over the RTB. I thought that was going to happen. The RTB, though, appears to be updating themselves and doing a lot of work to make themselves better and more accessible. So I don't think that's going to happen now, because it looks like the government's putting a lot of money into making the RTB stronger and better, hopefully. So I don't believe that I don't currently believe that the RTB is a target for takeover by the CRT. Oops. So here's the process. It can be broken down into 4 steps, which take more or less 90 days to get through. The first step is, and I'll go through each one of these in detail. The first step is self-help. There's a negotiation step where you try to figure out if you can work it out with your opposition. Facilitation step where you get a live person from the CRT trying to help you mediate it, see if there's some middle ground. And then finally, adjudication, which is when it gets put in front of a decision maker for a final decision. So I touched on this earlier, legal representation at the CRT. The CRT does not permit parties to use a lawyer. as their advocate unless a request to do so is submitted and approved by the CRT. So in my experience, the CRT has routinely denied all requests for legal representation. So I got one through one time, but the issue, what we were fighting about, was a strata matter, and it was in excess of $200,000. It was about $250,000. So that's another point here, is this CRT doesn't really have a jurisdiction on those types of matters. The sky's the limit for them, and they're happy to take it on. So it was a $250,000 matter. Opposing counsel was a insurance appointed counsel. So the CRT, I think, saw some merit there to have lawyers involved in what was a bigger and more complicated case, and took definitely longer than 90 days to sort out. But other than that, they've routinely denied it. So I've seen them deny legal representation in instances where the claimant couldn't speak English, or wasn't very good at English, or couldn't type. And I've seen it denied where the claimant was under a disability. So someone who maybe had a mental incapacity, or wasn't able to access technology because of a physical impairment, denied. It makes no sense at all. So they're very much interested in making sure that guys like me don't find their way into in front of them. And there's been various fights from other lawyers, specifically the Strata bar, because we're most entrenched and have the most sort of at stake in the CRT, about whether or not lawyers are allowed. And it's got all the way to the Court of Appeal. And the Court of Appeal thought, this is really stupid. It's like this fiction that the CRT has created, that there aren't any lawyers there, because of course there are, because my clients simply retain me to write everything for them, and then I email it to them, and they cut and paste it into the CRT document, and then email it to the CRT. And sometimes there'll be an email trail, and the CRT sees exactly where it's coming from. It's coming from me to my client to them, and they simply forward it on. So it's very artificial and ridiculous. But I suppose the idea is that, at least when it came to Strata, they tried to, there's this fiction that they're evening the playing field, because Strata corporations always had lawyers, because they have money they store in a bank account they can pay lawyers with, and individuals didn't. So the individuals were always at a disadvantage, they seemingly, and I think that's why they did it. But it's really one of these goofy things that we just, everyone thinks is kind of silly, but they are determined to carry on that way. CRT allows lawyers to act as helpers. They understand that people can be behind them as helpers, and lawyers are actually noted in legislation as someone who is a helper, but we cannot be seen as a primary contact or standing in your place. Jurisdictional issues. The CRT has the power to decline jurisdiction over matters if they feel it's too complex. And that has happened a few times in strata matters, because some of the strata matters can be quite complex. And so they'll say, well, we're not going to deal with it. We're going to send it right to Supreme Court and let a judge deal with it. But it's pretty rare. I think I've only seen it, maybe me personally, seen it maybe twice or three times in the 4 years, almost 5 years now CRT's been around. So the first thing you're going to do, and I would encourage you to go to the Civil Resolution Tribunal website. It's actually pretty good. They've spent a lot of time trying to figure out a way to make sure that this is very accessible to the public. And if you go there and you say, well, I have a dispute, you get to choose what your dispute is about. There's a drop-down menu. Is it strata? Is it debt? Is it societies? Is it co-op? Is it roommate? And then you're directed to this Solution Explorer. So you cannot commence an action, the CRT, unless you first go through the Solution Explorer. And the Solution Explorer is a bit of AI and artificial intelligence, and it tries to figure out what it is your problem is, and then tries to solve it for you. A lot like, say if you use TELUS, they'll, instead of like encouraging you to phone a live person, they'll try to get the computer to figure it out for you. So it's a lot like that. And sometimes it's really good, sometimes it's not. And then it usually ends up with, like, say, well, did you ask the person to pay you if it's a debt claim? And then you can say, well, yes, they refused. Then it allows you to go on to the next step, but you must do this. At this stage, you get like a claim number that you use as a reference to continue on. And by the way, you can come and go. You don't have to do it all at once on the internet. Like if you're busy or it's dinner time, you can, leave the process or log out and then come back when you're ready to carry on. So it's basically at your own convenience. So when you get past that solution explorer and you said, well, I've done everything I can do to try to resolve this thing, I want to actually file a dispute. So it's an online document submission, and you have to outline your dispute. You have 5,000 characters to do that. So it's mostly a summary. A lot of people don't understand that. They figure, well, I got to put everything in right now, including all my evidence, which is you don't do that. And it tells you there, please don't do that. Just give us an outline of what it's about. Sort of like a statement of claim or a notice of civil claim, if you've ever seen one of those in the Supreme Court venue. Like I said, you only have 5,000 characters to do it, so you have to be fairly brief. And there's a $100 filing fee, which they take online by credit card. The service of the dispute. So once you get it in there and you pay your fee, you'll get like a document, or you used to get a document to download. And at the point, there was a point where you were compelled or required yourself as the claimant to serve it on the other person. And that was always a problem. Well, what's happened now is the CRT has taken on that obligation of serving that person, much like the Human Rights Tribunal does. And they're the ones who are now going to send it out to the person, and they can do it by email. They're allowed to. So part of your application process is you have to identify who it is you're after. So you would put that person's name, their address, and an email address, and the CRT will like just email it to them and say, well, you're deemed served. And they keep track of when it is that these person's supposed to respond. So if you ever get one of these CRT things in your inbox and you think it's junk mail, think again and make sure look at it carefully, make sure it's not like some virus or something like that. But you have a look at it and maybe you want to open that and figure it out, because that might be notice of the claim, which you should be answering. And if you ignore it, there's a chance that default judgment will be taken against you. So if you get one of these things, you open it up, you have the ability to file a response, and you should do that, and you'll have a time limit. It's usually about 14 days to do it. And you file your response, and then the next thing you'll get by email is an invitation to do online party-to-party negotiations. So what they do is they give you a link where you can join in like basically a chat room with the person you're disputing with to try to figure out if the two of you can do something about it. I always bypass this because if you're with me at that point, you're way past trying to negotiate person to person. And there's way easier ways to do it, like just phone calls or letters is way easier than trying to use this thing. This sort of makes it seem official, and it's a little more impersonal, and you can just chat when you feel like it on your own timeline. But most people just bypass this part of it. The next part is like a really interesting part. It's called facilitation. And this is where you are invited to call in and speak directly with a facilitator who is an employee of the CRT, not an adjudicator, but sort of an intake worker. And your opposition will also be asked to phone in. And anything can happen at this stage. Like I am constantly surprised by what crazy stuff happens at facilitation stage, because there's no rules or procedure or direction from the CRT as to how these case managers are to, handle this rodeo. I've had things where my clients have started talking about their cases and just basically read from a prepared statement, and the other side did the very same thing, and the case manager said, oh, okay, all right, well, I guess we're going to adjudication. It didn't help at all. They did nothing. I don't, as far as I know, they're eating lunch while they're listening to us. But more lately, I've found that the case managers on facilitation have been interventionalists, which is that they get involved, and sometimes in a very partisan way. And I found it to be of great value lately, because the facilitators can be proactive in the settlement process, and they often get a sense of who's going to win this case. And often I found it really helps to have us talking on the phone call, because of course lawyers are persuasive, and we know the right words to say to cause people to come over to our side of thinking. And so I've had some success that way. Now, technically, I'm not supposed to talk because I'm not supposed to be there in the first place. So when the telephone conference happens, you phone in, you're in like a conference call, like everyone's listening in. The facilitator will say, okay, who's on the call? And my client will say, well, me, and I'm here with my lawyer. And the facilitator will say, oh, well, Mr. Haddock can't speak, of course. And we'll go, yeah, of course not. I'm just listening. Now, typically, like I do on an RTB hearing, I'll push mute if I have to speak to my client about something so no one can hear, and then we'll go back at it. I've found more often that the facilitators will say that and then not mean it at all. And all they want to do is hear from me. and they open the door for me to talk, and I do. And so I've had some cases where things were not going well for the opposition, and then the facilitator says, well, I'm just going to end this conversation. I'm going to call your opposition, Mr. Bad Guy, directly and talk to him about it. And I go, well, that's crazy. I mean, what's open about that? I mean, first of all, I'm fine, because she's going to go, whoever the facilitator is going to go and just take it to the opposition and try to make them settle. But I mean, how crazy does that sound, that you're not able to hear what's being said? You've got like the adjudication process administrators talking directly to your opposition, and you don't know what they're saying, and you're not a part of that. It's not open process at all. And that's what's happened. I've had a couple of cases. I'm pretty sure the facilitator got off the call, phoned the other side, and said, look, you're going to lose. You better settle this thing right now. I have no idea. I'm not a part of that. But I'm not sure why they do that, but I'm pretty sure that the reason is policy, because they have so many cases at the CRT right now that there's probably a push on to settle them as efficiently as possible. And that includes phoning people directly and trying to get them to settle. So if that doesn't work, you're moving on to the adjudication. There's case management. So the CRT will move to this case management support. This is basically a narrowing of the issues to be determined and an organization of the evidence required for hearing. So if you can imagine all these non-lawyers in there, many of them, especially if they're strident or have an axe to grind, think everything is important, like everything, all the letters they've sent to the Prime Minister, everything. And they have to be sort of guided so they don't completely like flood the system with irrelevant materials and then take away all the intricacies of this process. There could be various applications by the parties during this time too for document production and third-party proceedings. They don't have the same rights you have at Supreme Court with regard to that. So it's it can be a bit of a hard thing for the case managers to make sure that people are only sharing relevant stuff or not, or making sure they do disclose relevant stuff. The document disclosure is always the hardest part of this, at least for lay people. For this firm, we've got programs that convert our PDFs and number them and put the right numbers on them that the CRT wants, because they want them in a specific way and they want them prepared and uploaded in a specific way. And that can take a long time if you've got a few documents, and if you're not really tech savvy, that can be kind of hard. So I think I've seen a few situations where people were kind of hosed because they weren't able to correctly leverage this ability and they got kind of stuck. So anyways, for us, it's easier. It's not, it's one of the more expensive and arduous parts of what we do, because we have to make sure everything's done correctly. But that if there's one failing, it's the document disclosure part of the CRT is not super easy to deal with. And once you've done that, you then move on to something called the trial decision plan. So you may or may not have to prepare what's called a tribunal decision plan. And again, there isn't any rules, apparently. You're just either told or not told to do a trial decision plan. Some of the debt claims that I've been involved with, the small ones, there's no trial decision plan. It's just not very complicated. So I guess they're not wanting to do that. But usually the trial decision plan, or TDP for short, is a Word document. And it's where your submissions and written arguments are prepared by both sides. And so it's a lengthy Word document, and it's got cells which you can type into, but it's basically going to list all of the information that you've already submitted. So that it'll have that very first submission with your summary in there. It'll have the response submission. It'll have the list of documents, not the actual documents themselves. And then it'll have a section for argument. And this is where this is where you set out your best case, like your facts in chronological order, your argument, and your law, if you've got law. Of course, so many lay litigants there, they're not terribly concerned about law. And it can get lengthy. I've had some really long ones that we've submitted. And sometimes new evidence is permitted. Sometimes people forget at a particular stage to add the evidence they wanted to add, and the CRT allows you to put new evidence in if you ask. So hearings, once you finish the TDP, there might be a hearing, but most likely not. Telephone in-person hearings are provided for, but I don't know of any ever occurring. have not heard about it. And I probably would hear about it because a lot of us Strata lawyers are doing stuff there. And if anyone ever got in front of an actual hearing, I'm pretty sure that'd be news among us. It's very likely the CRT will simply proceed on documents and written submissions after that TDP is finalized. So that's where, you know, you can be a real winner if you hire lawyers to do this for you, because of course we know how to do it and we know how to be persuasive and we can be pretty quick about it. We can tackle the interesting points and the things that we think are going to be of most interest and critical to the adjudicator. So you have to wait to get your decision. They often advertise it'll be done in 2 weeks. It's almost never the case. I usually wait about 6 weeks for these things to come around. It goes to an appointed adjudicator. These people are actually employees of the government, and they're adjudicators or tribunal members or judges, I guess if you call them that. But you can see why the personal injury bar was really angry about all of this, because they're saying, and they're right, is that, well, ICBC is a government entity. So here I'm dealing with government employees, because ICBC adjusters aren't paid for giving away money. Why would these guys get paid or bonuses or promotions for, you know, giving money, ICBC money away? So there's a conflict issue that has never been worked out there. But you'll get a written decision eventually. And if you don't like it, there's really not a lot you can do. There's some limited appeal provisions under the Judicial Review Procedure Act. But then you're going to Supreme Court. You definitely should hire a lawyer. You don't have to, but you probably should. Many of you have probably done JRs before on residential tenancy branch decisions. It's basically the same type of process with a petition and affidavit. But the grounds of appeal are slightly different. They're actually a bit lower threshold. Like for RTB, it's got to be like patently unreasonable, like a dead wrong decision. CRT is lower threshold. It's just correctness there for most things. We're still working it out because it hasn't been a lot of JRs on the CRT, and the CRT Act is written very poorly. So part of it is expert, like RTB, and part of it is not. So it's quite confusing trying to tell clients exactly what the standard is. But regardless, even if it's correctless, it's still really hard to appeal one of these decisions. So I've put in here a little table as to what you would follow and how the procedure follows along. That's I'm sure this PowerPoint will be made available to those who are attending, and you can maybe use this as a little snapshot of how the proceeding goes. So CRT and residential tenancies, where are you going to run into these things? I think mostly it's going to be strata property. This is where, if you're renting out strata property, this is where you're probably going to run into it. So I've had a couple of them, like for instance, I'll give you a few examples of these things. I had a client who was rented a very high-end condo unit in Cole Harbor, and he rented it to a company, and the company's business was doing Airbnb. And I don't know if my client knew that or not, but he just knew the person. And the Strata Corporation changed their bylaws to say, well, no Airbnb allowed, and then included that $1,000 a day fine in case you get caught doing Airbnb. And so my client, not paying attention because he has numerous strata lots that he rents out, didn't really pay attention to the notifications from the Strata Corporation about Airbnb happening in his property, and then racked up $60,000 in fines, if you can believe it. But that's 60 days at $1,000 a day. And of course, my client goes, well, wait a second. That's not cool, because my tenant, of course, has the Form K, and the Form K has got the bylaws. So the tenant knew that he shouldn't have been doing Airbnb because it says in there you can't. And so I said to my client and my junior who was doing the case, I said, well, my client, we're not going to eat that 60 grand and try to chase this guy. We're going to bring him in as a third party. And we did successfully brought that the tenant in as a third party. And then we're successful in transporting not 60,000 because they couldn't prove it, but they did prove 15 grand, transferring the 15 grand onto the tenant. And now the tenant has to pay the 15,000 bucks. And of course, we ended the tenancy as well in the RTB. because they were breaching the bylaws. And so we had these two things going at the same time. We had an RTB eviction process going on and this big CRT claim at the same time. So there's an example of how that can happen to you if you're a landlord who is renting out strata property. Debt claims, right now it's 5,000. I am pretty sure that's going to get raised, and I don't know where it's going to go exactly, but I wouldn't be surprised if one day, maybe not soon, it goes to $35,000, because they are clearly handling those kind of debts or those kind of claims as far as MVAs go, and as far as strata property goes. So there's no question they can handle 35,000. That's the jurisdiction for small claims right now. And wouldn't small claims be happy to get rid of small claims completely? Provincial court would love it, because then that would take a lot of the workload off and just put all that stuff in the CRT. So debt claims, you're not going to really deal with that with residential tenancy, because those can be dealt with at the RTB for money owed under the residential tenancy agreement. But think more of suppliers or contracts you have for services, contractors, things like that. It's more outside your business operations. That's where you're going to run into these things where someone says that you owe them money, not necessarily a tenant, or you want to go, or you say that someone else owes you money. Roommate shared accommodation, I touched on that a little bit. I know Hunter told me a story about someone who got caught up in that, where the CRT decided, despite the evidence, compelling evidence to the contrary, that that there was a shared accommodation because the tenant on occasion used the landlord's kitchen in a different part of the house and took jurisdiction over it. And there you are, you're stuck there because they've decided that it's a roommate or shared accommodation issue. You're going to have tenants going to the CRT by mistake. I haven't had that happen yet. But you know, I have a lot of, in my co-ops, housing co-ops, I have a lot of co-op members going to the RTB by mistake, and the RTB doesn't turn them away. They take on the jurisdiction, or they take it on, and then hopefully someone tells them that this a fact does not belong on the RTB. You may get stuck doing that. You might have to, your first submission or response would be that this doesn't belong in the CRT, it belongs in the RTB, but you'll have to take the steps to do that. Otherwise, you might get a default judgment, because my experience with the CRT is they don't care if someone's done something wrong as far as a claim has been made. If you don't respond to them and say, this is wrong, they might give you a default order no matter how wrong it is. So I've had that happen a number of times in the strata world, is someone has made like a completely wrong claim in law, CRT could not care less, just close the file, give them the order if you don't respond, and you're done. So you got to watch out for that. There's tenant versus tenant issues. Now you might be a spectator on that, but you might get drawn into it because they'll just name you as a party if you've got disputes between tenants that somehow might land up in the CRT. And then this is a little known one, but tenant associations, like this used to be a bigger deal, I think 10 years ago. I don't know how many tenant associations I worked with, but there is such a thing. There's and it's recognized that tenant associations can exist within your building. So they could, create their own little group. And I've seen them come after landlords in residential tenancy situations, but they might get smart, and they might see the CRT as an opening for them to get the kind of orders that they want that they're not really able to get at the RTB. So I haven't seen it happen yet, but it's on my radar. I'm just warning people about it. Nothing you can do to stop it, of course, but it's got to be alert to when it happened. You can't simply just say, oh, I'm not going to worry about it. Here are some of the bigger issues to consider. Vexatious claims. And some people will go to the CRT because, remember, it costs nothing and there's no gatekeeper function at all. So there's nobody there at the CRT saying, no, your claim is like ridiculous, it's absurd, we're not going to accept it. There is at the Human Rights Tribunal. So there's a gatekeeper function. Somebody at the Human Rights Tribunal will look at these things and go, well, you haven't set out what you want, and then they'll send it back to the person to figure it out. No such thing at the CRT. It just goes in, they pay their fee, claim started, you got to deal with it. There are limits to online dispute resolution. So if you wanted to, like I said earlier, party-to-party negotiation, probably doesn't work very well. You're really not talking to people on the phone. You're not meeting them in person. The best chance you have of that is during facilitation, when you have the person from CRT helping you with it. There's problems with self-representation because there's just not the knowledge base there. People will sometimes just go on emotional arguments rather than legal arguments, and then just get all caught up, go the wrong direction, put in the wrong documents. Evidence is just not good or faulty. And there's no cure for that. The CRT will not help you, even though you might be shooting yourself in the foot. They're not going to say, oh, you should maybe consider doing something else. They're not going to do that. And they discourage you in a way from seeking the help of lawyers to put your best foot forward. Recovery of legal fees, there is no recovery of legal fees, except in the strata context. There's recovery of legal fees there. So if you hire someone like me to help you, you're not going to be able to recover those fees at all. There's only, and it's not much better than what happens at in the Supreme Court anyway. You certainly can't recover legal fees at RTB, even though we're hired on many occasions to help in RTB matters. Small claims, no real recovery for legal fees there. And at Supreme Court, there's only, rule of thumb is about like a third of your legal fees are recoverable under a tariff. So here, definitely not. There's actually a line in a section in the Commercial Tenancy Act that says legal fees will not ever be awarded to anybody, because people always ask for them. And I think I'm almost done. I'm done. So that's the end of my presentation. I think I'm pretty much on time. It's 12:40 or almost 1:45. So I guess it's Q&A. Hunter, do you want me to stop share or?
You can keep that up for now. Okay. Yeah, that's fine. I think your contact information is important for people to get.
Okay.
So we'll give people a chance to get that information. Thank you so much, Grant. Great presentation. Obviously, very interesting information. And I think new for a lot of people, because, I mean, as we said at the very beginning, this is a new tribunal in general. And, the chances of actually ending up there are not super high, but it's important to know what it can be used for, and what to expect if you are taken there.
Yeah. I think it's actually not super high yet, but I think that we got to be prepared as an industry. We should be prepared for this thing. Like, for instance, the societies and co-ops didn't know that they were going to be sucked into the CRT, but they had an inkling this might happen. Mm-hmm. So that industry, they prepared like at least a year in advance before it happened. Right now, I hear no rumblings about residential tenancy being somehow sucked into the CRT, but my view on it is that this is, like I said, it's the future. So I think we need, as an industry, to be a little prepared for something like this to happen.
Well, and I think that the residential tenancy branch is in they're in a situation where certainly they're looking to the CRT. They're seeing that model. Mm-hmm. And we've seen that in the way that they've started to update their online processes. Yeah. Their intake process is much more streamlined. And I think there's that groundwork there to improve their services and to continue to improve their services, to perhaps maybe not make it the same as the CRT, but perhaps more in line. And as you say, yeah, not sure that there's necessarily any move to have them take it over at this point, but certainly to learn from right. In both cases. Yeah. I know there has been a lot of crossover there in terms of conversations. So one of the questions that have come in here is, what are the qualifications of the adjudicators or these judges?
Ooh.
Yeah, there's the face.
Interesting. I have to watch out for libel and slander right now. So, well, I know that half of them are probably lawyers. So if you go to the website, they'll actually list the adjudicators and what they do. And so I'm, at least for the strata side, at actually the vice chair of the CRT is a guy named Garth Cambray. And Garth Cambry he used to own a strata management company, a big one called Strata West. And he's one of the better, smarter strata guys. Now, he's not a lawyer, but he's the vice chair of the CRT. The rest of the people there are, at least half of them are lawyers. The second vice chair is a lawyer as well, but she comes from an employment law background, and they don't deal with employment law at the CRT. The rest of the people, like, there are people that will adjudicate these things that are not lawyers. So their training is, I don't know exactly what their training is. You'd have to look on the website to see what they're doing. For the work that I do with the strata, almost always it's someone with a legal background that does my strata decisions. The small claims ones, like there's people who do not have legal backgrounds that are doing the small claims ones.
That's interesting to know.
Yeah.
Yeah, and then that's not entirely dissimilar with the residential tenancy branch. Arbitrators at the residential tenancy branch are not necessarily from a legal background. Oftentimes, their hiring practice at the RTB generally means that they want people who are have a background in mediation, in conflict resolution. Sometimes it's a legal background. For the longest time, it was retired judges on contract. But I think that's pretty much gone out. There's not many of those left behind. But yeah, so it's very similar. It's not necessarily always a legal background, but I think perhaps an eye for people who have that kind of even keel and can ascertain what the nature of an issue is.
Yeah.
So in the residential tenancy branch process for dispute resolution, there's a time frame for disputes. For a monetary order for either party, it's generally 2 years after the tenancy ends. Is there something similar for the CRT? What are the types of timelines for this, and when do they perhaps expire?
Yeah, the CRT has the usual Limitation Act timelines. So there's probably some different timelines in the RTA, Residential Tenancy Act. CRT, it's the general same timelines as you would have if you were going to the Supreme Court or small claims. So you got 2 years for debt or MVA, 2 years in which to make a claim. And then for everything else, it's 2 years from the date that you knew or ought to have known that you had a claim against someone.
And that's a very interesting distinction and something that's different from the residential tenancy branch, because it's 2 years at the residential tenancy branch, but it's 2 years from the date the tenancy ends, which means you can have a 10-year tenancy and a date and a debt that maybe was occurred at the very beginning of that tenancy, and not collected till maybe 12 years later. And that's unlikely to occur, that you'd have a tenancy that long, but you could. And I think that's the important part to know there is that when you do have a debt, if it's something that the CRT is going to handle, know that time frame starts immediately.
It does.
As opposed to waiting for that relationship to end.
Right. Yeah. Well, we dealt with that a number of years ago with strata property. So if you didn't pay your strata fees, there was a time when everyone thought that was just simply a continuing contravention, just carried on. And then the courts eventually said, no, it's not. I mean, if you don't commence an action on that debt that occurred 2 years ago, you're not getting the money back.
Exactly.
Same thing for RTA. I think if it's 2 years old, it's not continuing. You have to take action on it.
Yeah. So another question here is, can a property manager, you say that lawyers aren't generally involved in this, or at least in person, and not that it's in person, but on the call. Can a property manager act for a strata counsel or owner?
No, they can't. I've seen them do it, but because don't forget, I don't know if I should even say this, but the CRT has no idea who is corresponding to them, really. And so I know of instances where somebody has created a Gmail account, strata at Gmail, whatever, and gave access to everybody, right? And so I've seen, if you read some of the strata decisions or any CRT decision where there's a representative, they always start with who's involved, and they'll say the owner is blah, blah, blah. And then it said the strata, who I assume is represented by a strata council member, blah, 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 because they don't know. Somebody's written in something for the strata, but they don't know because you never speak to them, except on the facilitation. You would have to have the strata member there. But I think that if you were a property manager and you tried to write on behalf or submit on their behalf, I bet you get a email back from the CRT saying you can't do this. It's got to be a person, a representative from the strata corporation.
And again, that's something that's very similar with the residential tenancy branch. They don't have a database of landlords and tenants or properties that you own, so an application just simply goes in. You brought something up during the presentation that I want to touch on again, because I think it's quite important. And it actually goes to another topic that we've had you on here before in the past talking about, which is collections. And it was that there was a situation that you had where a strata was issuing fines because the tenant was running an Airbnb, and the landlord owner had these fines essentially reallocated to the tenant, meaning they don't have to collect. Right. So is that something that is a common thing? Is it a fairly straightforward process? What does that look like?
Well, it's not common and it's not straightforward. So a lot of, if it was the Supreme Court, it'd be simple to file what's called a third party claim. You'd say, well, it's okay, like you fined me, yes, technically I owe the fine, so I'm not really responsible for it. It's this other person you haven't named, so I'm going to third party them in. You can do that at the CRT, but it's cumbersome and you have to talk to the right people. And again, there's this ridiculous, because your client, there's no way they can figure that out, but there's this ridiculous thing where we have to go through our client, but you'll get what you want. Eventually they'll allow you to third party the person in there, but it's not common, because I think the reason it's not common is because I don't think the CRT encourages you to think that way. That a lot of they'll come back and say, well, I'm sorry, that's hard to do, or you can't do, or there's not a process, or they won't tell you what the process is. And so I've seen people go like they're stuck, right? They go, oh gosh, how do I add this person? Doesn't seem to be a way to do this. So we've worked that through on various occasions. So for us, we can do it. It's not easy. And then collecting on it, it's interesting as well, because you don't sort of like, you still remain the person who has to pay the debt. So the strata would want the $15,000 from my client, but we have the ability to collect that $15,000 from the tenant at the same time. And it works kind of the same way as any sort of debt that you would get at the RTB, is that you could file it in the CRT, you file it in the Supreme Court. I think, you can file in provincial court if it's within their jurisdiction under 35. So in this case, we would be filing this CRT decision in the provincial court. And then if we had to, if the guy wouldn't fork over the 15 grand, we'd have to take whatever execution processes that we could do against him to get the money back.
Okay, well, that's interesting. That's good to know. So it's not so much that the debt is completely removed from the owner, but the tenant is listed as a party to that.
Right, it is. Yeah, so you have the ability to claim over. So for instance, like if the tenant's insolvent, that doesn't mean that nobody pays the claimant, the strata in this case. So the strata somebody owes the strata $15,000. That's been established. So the first person that owes the $15,000 is you, the landlord. You just have the legal ability to also like reimburse yourself that $15,000 and collect it from the tenant itself. If you're lucky, like if there's lawyer, like say it was a Supreme Court case or something like that, and there's lawyers involved, we wouldn't put each other through that ridiculous step. We'd simply just arrange for the tenant to pay the plaintiff directly. But with the CRT, there isn't that kind of help. So again, and there's not the lawyers involved, and there's not a process like you'd see at the Supreme Court. So it's a little bit more of a dance there about how that gets done.
So we focus a lot about decisions, and specifically around how that often deals with money. Is there other types of decisions that the CRT can issue?
Yes, they can. Yep, they can issue orders. Their jurisdiction is quite broad. So, for instance, in the strata world, they can order a strata to stop doing something or do something. So that's non-monetary. Same thing for the co-ops and for the societies. Debt claims are easy; just pay the debt. And I would, for roommates and for shared accommodation, same thing. They might order someone to refrain from doing something or to do something specific. And I would expect that, sorry?
Or to move out?
Yes, move out orders, yes.
Yeah.
You would have to do that. And I would expect that there'd be like other orders that are non-monetary that might go against a landlord in those circumstances as well.
Certainly. Yeah, that's definitely a possibility.
Mm-hmm.
Yeah, there are more questions that have come in. Is this something, are the decisions that are made through this process published? Is there
Yes.
a link to case histories?
There is. It's pretty good. It's not the best search engine in the world, but if you go to the CRT website, they're searchable by topic. So you can search all the society decisions, all the roommate decisions, and all the, of which there are not many, by the way. This is relatively new. But yeah, they publish them. They're generally available on another one called Canlii, Canlii. So they're published there as well. And there's so many going through there. They must publish 5 or 6 or up to 10 a day because there's that many things running through there.
Great, that's really important to know, and I know that's something that can be really helpful in residential tenancy matters as well, looking at past decisions. While they're not necessarily precedent-setting at dispute resolution in the residential tenancy branch, it's still good to know what arbitrators have done in the past.
Yeah, it's easier to search on CRT than it is on the RTB.
I can only imagine.
Yeah, it's hard searching on the RTB.
It really is. And so, let's see here, I think there's a few more. So the question here is, if you have a nuisance case between 2 occupants in different units they're really, it's getting to the point where they're almost harassing the landlord and strata council, who would take this to the CRT?
Wow. Oh. Well, it depends. Whoever wants to strike first, I suppose. If you're a landlord, your remedy would be to go to the RTB for nuisance, for unreasonably disturbing other people in the building, if they're also your tenants. If you're the strata corporation and you've had it, you would go to the CRT to have them removed.
And I think that's an important part that perhaps we can end on. It's just kind of understanding again that there is that while the CRT is a great tool in many ways, despite Grant's attitude towards it, it is not. It doesn't replace the residential tenancy branch and their processes. And there, while there sometimes occasionally can be overlap in these, you need to know which one is going to take the jurisdiction. And as Grant mentioned earlier, they're not going to tell you up front whether or not they have jurisdiction. They might not even tell you at the hearing itself properly. And as you mentioned, I had mentioned a story to Grant yesterday where someone had taken jurisdiction was decided that it was a roommate situation because they shared a kitchen. Really, the landlord let them use the microwave a couple times while their microwave was broken. So anything can happen. Always go prepared. As Grant had said there, always make sure that you're able to argue that point. So I think, is there anything else you want to add, Grant, before we?
No, just like I said at the beginning, I've got a bad attitude about this just because of where I'm from. I can't help it. It's my mindset. It's, lawyers want to have, perfect justice. We want all our evidence in. We don't want a hearsay. We want it done perfectly, right? Because that's what our clients expect. That's how we're trained. This is definitely rough justice, but I think, is it more good or more bad? I think it's more good. because it allows the public access to justice where I think justice is denied in a lot of situations simply because of complexity and cost. So I'm one of the few lawyers who would come down on it's the good side. Most of them just have nothing but complaints about how it's done, and they just see it as a situation where their clients are not able to put their best foot forward. But I see it as an access to justice issue, and I believe access to justice is really important. And information to do that, and the ability to get your disputes resolved quickly, efficiently, and in a cost-effective manner.
Certainly. I mean, access to justice is one of the part of our society in general. So that is, having more ways to do this, obviously, perfect or not, is definitely an improvement. So thank you so much for this. If you, as participants, enjoyed hearing Grant speak today, then you'll be pleased to know that you can hear him again on April 8th at our virtual education day. This event is going to bring you 4 great sessions. It starts with a Landlord 102, which is the second part of the education provided across BC in the fall of 2019. We also have Scott McGregor from the Residential Tenancy Branch. He's from the Compliance and Enforcement Unit. We have an expert legal panel, which includes Grant as one of our panelists. On that panel, we also have Michael Juilliard, lawyer with Harper Gray, and Clara Mega, partner at Singleton, Rugerhart, Reynolds, Vogel. And again, of course, as I mentioned, Grant and I will be moderating that one. We also are pleased to announce that we will be having the Honorable David Eby. He is the Attorney General and Minister responsible for housing, and the session will have a Q&A there as well, and end with a short Q&A with myself. You'll get more information about this through our e-news. If you are not a member and you're not receiving our e-news, go to landlordbc.ca, scroll down to the bottom, and sign up for our non-member e-news. If you are a member, watch for our e-news. They come out regularly with information about this great event. Thank you and have a nice day.